Welcome to this first presentation relating to Chapter 5 of our textbook. In this chapter, we'll discuss constitutional law. When I use the term constitutional law, I'm talking about the U.S. Constitution. Obviously, in the state of Texas, we have a state constitution as well, but our focus today is going to be on the U.S. Constitution. So let's get started. A very important idea that we need to hold in our heads whenever we discuss the Constitution is the idea of federalism. And I would even go farther and say, really, whenever you talk about the law generally, somewhere in your mind you need to have this idea of federalism because it's really essential to understanding. And it's not necessarily the most intuitive idea. There are advantages to it, but there's some pretty significant disadvantages to it. It's one of the reasons why these disadvantages are one of the reasons why many countries have chosen not to be organized as a federal type style of government. And of course, let's talk about what federalism is. It's when there are two locations for power. I guess there could be more than two, but generally speaking, there's going to be two locations for power. In our system, we have a national government, which we usually call the federal government, and we also have our state government. And so there are certain things that the state does. When I say state, I don't mean, again, the state is an ambiguous term because it can refer to one of our political organizational units such as Texas, Oklahoma, Louisiana, or it can refer to a whole country. For example, we might say the state of Israel. Obviously, Israel is not a state in the sense Texas is a state, it's a whole country. So when I use the term state here, I mean one of the 50 states. And when I use the term national or federal, I'm referring to the entire country just for clarity's sake. So as a result of this organizational system, there are certain things that the state can do that the federal government can't do. And there are certain things that the federal government can do that the state can't do. And then there are certain areas where both can act. And so you kind of have to be looking both ways. For example, I'll just give you a couple of examples. Almost all of our criminal law that we have in the United States is state law. It's pretty tough to violate a federal law. One of the most, well, I guess there's two kind of common federal laws people violate. One would be income tax evasion, and the other would be drug offenses. But for the most part, your average ordinary murder, rape, robbery, things like that are not going to be federal crimes. And I'm not trying to trivialize them. Obviously, they're a big deal if you do those things, but they're state law violations. And so that would be an example that you want to focus upon state law. But then there are other areas where you want to focus on federal law. For example, most of the regulation about employment relationships you'll find in the federal law. So there's that dichotomy there. You have to know where to look, where that locus of power might be for that particular area. And we had that throughout our system, that there is this division. There's some good reasons for the division. One reason is that there may be certain laws that make sense in one part of the country, either because of geographic or cultural reasons, that may not make sense in other parts of the country. For example, there might be certain agricultural products that a particular, oops, sorry about that. Here. I apologize for that. That was the Smart Book. Anyway, so I'll go back to this. Here we go. So as I was saying, there might be a particular crop that is grown at a particular location that makes sense for there to be certain subsidies, for example, for that crop, or maybe there's a certain tourist attraction in that particular state. Or there could be some cultural differences. For example, there are certain states in the United States that think recreational use of marijuana is appropriate state policy, other states that would disagree with that. And so it allows for there to be some differing answers to those questions. And so that's an advantage of federalism. It allows one country, but with different answers to questions. So it allows states to be somewhat distinct. Another reason why some people think that federalism can be a good idea is that it allows there to be two focuses of power. You may recall when President Obama was president, our Attorney General at that time was Greg Abbott, and also for part of the time was Ken Paxton. Anyway, both of those individuals several times sued the federal government on behalf of the state of Texas. And of course, if the state of Texas were just an extension of the federal government, it wouldn't be able to sue itself, right? So it's only because they're legally distinct that the state of Texas was able to sue the federal government. Maybe that was a good idea, maybe it wasn't a good idea, but it shows that one branch of government can challenge another branch. And so no branch becomes all powerful. And so it allows for there to be some back and forth. But we've seen it the other way too. The federal government has sued Texas at times. For example, fairly recently there was a dispute, or there was a contention that the city, I believe it was of Pasadena down in the Houston area, had violated the Voting Rights Act. And so there was some concerns about that. The federal government sued that particular location, the state of Texas. So again, there's that balance between the federal and the state, and that allows there to be some checks on the power of one versus the power of the other. So those are some advantages of federalism, but of course there's a huge disadvantage, which I'm sure you've already thought of, and that is how inefficient. I mean, we have two court systems, we have, two criminal investigation methods, we've got duplication of efforts all over the place. If a business person wants to find a law, he has to look in two places. He has to look on the state level and the federal level. And so it takes more time, there's more hassle, there's more uncertainty, there's more bureaucracy associated with a federalist system. So there's some advantages and some disadvantages, and you can see how reasonable people could differ about which system is better. When you have a federalist system, though, you usually need to have a tiebreaker. It's a little bit like if you happen to have a court that has, we'll say, two judges on it. Well, what if the two judges disagree? What if one judge votes to convict and one judge votes to acquit? What do you do with the defendant? You need to have a tiebreaker. That's why we almost always in our system have an odd number of judges. So there's at least one person who's going to be able, when everyone votes, that there's going to be the ability for us to decide, how that all plays out. Okay, our tiebreaker is the supremacy clause in the U.S. Constitution. And this clause says that the U.S. Constitution is the supreme law of the land, but also the laws and treaties that the federal government enters into is supreme law of the land. So if there's a dispute between a state law and a federal law, and the federal law is constitutional, meaning that the Congress did not legislate in an area in which it did not have authority, so that both the state and the federal entities were appropriate in the law that they passed, the federal law wins. It is supreme over the state laws. It's the tiebreaker. The federal law is the tiebreaker. And this idea is federal preemption. You can see in the term preemption, pre means before, and this means to take before, or to get in front of it in line. So the federal law jumps ahead of the state law in line and says, the federal law is going to apply before the state law applies. And sometimes this will cause the state law to be null and void. It doesn't have any effect because the federal law preempts it. There's a variety of types of preemption. That's not inevitable, though that will be what happens. Sometimes the federal law won't preempt the state law. The legislature actually says, we don't intend to preempt. We intend to legislate in our own little area and have the states legislate in their own little areas. Sometimes the federal law will say, well, we're going to preempt in certain areas but not in others. And then sometimes they'll say, yeah, we're going to preempt completely, the complete subject matter. So you actually have to look at the statute to decide what type of preemption the federal government has sought in this area. And sometimes the Congress may not have been sufficiently precise, so you have to actually look at the opinions that the judges have made with respect to interpreting that particular statute. Let's talk about checks and balances. Many times people confuse federalism with checks and balances. And I can understand that point of confusion because in a way, federalism does involve checks and balances. It's the balance of the power of the state versus the power of the federal government. But when we use the term checks and balances, when we're talking about constitutional law, we're really talking about a different type of checks and balances. We're talking about how the federal system is set up. And of course, we have three branches of government in the federal system. We have the executive branch, and that is where the president is located, and everyone who reports to the president is located. Then we have the legislative branch, which includes the Senate and the House of Representatives. And then we also have the judicial branch. It obviously includes the U.S. Supreme Court and all the other federal courts, which would include the appellate courts and the trial courts. This system is replicated on the state level as well, but we would look to the state constitution for the specifics about that. In the state of Texas, our system is very, very similar. For example, we have, well, instead of a president, we have a governor, and we have a legislative branch. We have a bicameral, or the two houses, just like we do in the federal system. And of course, we have courts. In our system, we happen to have two highest courts, unlike the federal system. But other than that, for the most part, the system works very, very similarly. So we're going to look at the checks and balances that exist between these three branches to see how these checks and balances will control and limit the ability of one of these branches to become more powerful. And of course, a concern that our founding fathers had was that if one branch became more powerful, it could abuse its power. You know, the idea of power corrupts and absolute power corrupts absolutely. The founding fathers were fairly cynical about the abuse of power, and so they wanted to rein in all the branches so that if a despot or an evil philosophy starts being promulgated in a particular part of our government, there was an ability for the other branches to kind of step in and check that abuse of power. We're going to go through briefly the various checks that exist. So we're going to look at the checks that the legislative branch, again, this would be Congress, has on the president, not just the president, but his whole or her own whole branch. Of course, one is that the legislative branch can refuse to approve the president's budget. One of the president's constitutional requirements is that he provide a budget, an annual budget. In recent years, that has become more of a symbolic thing. Presidents haven't always presented a realistic budget, but in past years, it was a more serious budget. And the bottom line is that Congress will decide whether to approve the budget or not, and most likely Congress will make significant changes to the president's budget before they finalize it. Of course, the legislative branch can overrule presidential vetoes. We'll talk about vetoes in a second. A veto is obviously one of the presidential powers that we'll talk about. But once a president, Congress passes a law, the president vetoes it, there is the power to override that veto. The legislative branch can refuse to approve presidential appointments. This became an issue fairly recently when President Obama was president, and after Justice Antonin Scalia passed away, he nominated Merrick Garland for the U.S. Supreme Court, and the Congress refused to consider Mr. Garland, Justice Garland, for that office. And so when President Trump became president, there was still that opening on the U.S. Supreme Court, and he appointed Neil Gorsuch. So that's an example of Merrick Garland's, the fact that he's not on the Supreme Court today is an example of how the Congress is able to refuse to approve presidential appointments. But it's not just justices. It could be people on the president's cabinet or other positions. Also, the legislature has to approve any treaties that the president enters into, and it can choose to impeach and remove a president. We have had two presidents that have been impeached. One was President Clinton. He was not removed from office, but he was impeached by one of the houses in Congress. And so that is a possibility. If the vote of both houses is to impeach and remove, then the president would cease to be the president. And in fact, the vice president would become the president. Probably the most historic time for this to become an issue, at least in recent times, was when President Nixon was president. He, in fact, wasn't impeached, but it seemed pretty clear that he would be impeached based upon his conduct relating to the Watergate scandal. And so instead of remaining president, in the face of the possibility of impeachment, he elected to resign his office, and that's how President Gerald Ford became president. So again, all these have to do with how the legislature, the Senate and the Congress, can control the president. And of course, the Congress also has the ability to affect the judiciary. It can pass, or I don't know if amendments is really the right word here, it can pass laws to overturn judicial rulings. A good example of that, we'll talk about this particular law in a later chapter, but it's the Lilly-Ledbetter Act. There is a law called the Fair Labor Standards Act, and that law was a long-standing law, but in the I guess it was late 80s, early 90s, the U.S. Supreme Court interpreted a particular provision of that law. The case in which it was interpreted was the litigant was named Lilly Ledbetter. And I think she was suing Bridgestone Firestone in that case. Anyway, the Congress so when the decision was announced by the U.S. Supreme Court, the Congress strongly disagreed with the effect of that decision. And so what Congress did is then passed another law. They amended the Fair Labor Standards Act, and they called the amendment the Lilly-Ledbetter Act after the plaintiff in that case. And as a result of that, they changed the law in that area. The U.S. Supreme Court decision interpreting the older version of the law was now meaningless because the law had changed and it was now in effect. The legislature also can impeach judges just like it can impeach a president. There was a fairly recent case in Texas, actually, where there was a district court, U.S. District Court judge in Galveston who was impeached. He had engaged in sexual misconduct and had lied about the sexual misconduct. He was convicted of a crime, and I think he spent some time being incarcerated. And he declined to surrender his office as a U.S. district judge, which is usually what happens. Usually the individual will resign his office because it's obvious that he would in fact be impeached. In his case, unfortunately, his wife had cancer, and she needed the health insurance that was provided through her husband's employment as a federal judge, and so he elected to maintain that health insurance for as long as possible, and that's why he didn't resign his position. Anyway, eventually he was impeached because of his misconduct while he was in office. And similarly, the legislative branch will, of course, approve the judges who are appointed to the federal judiciary, and they can set the locations of the courts and the number of judges in a particular court. There's been a lot of controversy, or some controversy at least, about the fact that the Ninth Circuit, one of our 12 circuits, actually 13 circuits really technically, one of our 13 circuits is really large and kind of overwhelmed by the coursework, or not the coursework, but the legal work that needs to be done. But it's also a circuit that has a reputation for being quite left of center, and also of making decisions that are controversial. And as a result, some members of Congress have been reluctant to break it up into two parts, out of the concern that then we would have two circuits that are significantly left of center. And so again, the power of the legislature has directly impacted the structure of our judiciary on the federal level. So now we've talked about, so we've completed talking about the checks that the legislature has on the executive branch and the judicial branch. Now we're going to focus upon what the executive branch, what the president can do. We already talked about this, but one of the most important powers the president has is the ability to veto laws that the Congress has passed. If the Congress passes a law, the president has a choice. He can or she can sign the law or veto it. If he or she signs the law goes into effect, and it will remain in effect until the law is changed, or until the court system finds it unconstitutional, which is, of course, a very rare event. But the president also has the option of vetoing or choosing not to sign the law. And if that is what he or she chooses, then the Congress, then the law doesn't go into effect. Congress does have the ability to override the veto, but it requires a supermajority. It's not an easy thing to do, and so as a result, that's a pretty solid check on the power of the executive branch. In addition, the executive branch has the ability to check the judicial branch. For one thing, the president appoints federal judges. Obviously, since federal judges have that position for life, he doesn't get, or she doesn't get to appoint judges that are already there. They're there for life, but he also has the power to pardon federal offenders. So if a person has been charged or convicted of a federal crime, the president has the power to pardon or to excuse them from the penalties of that particular conduct. He obviously can't pardon state law offenders. That would be the role of the governor, potentially, although that varies from state to state. So these are the checks that the president has on the legislative branch and the judicial branch. And of course, the judicial branch also has checks on the legislative branch and the executive branch. So let's look first at the legislative branch. This is a big one. We'll talk about this one in just a second, a little bit more detail. But the big one that the judicial branch has is it can declare laws of Congress unconstitutional. Now, you may recall, let's talk about this first. So when the judicial branch declares a congressional act unconstitutional, it means that law is null and void. The Congress can't fix it unless they change the law in such a way that makes it constitutional, or unless they pass a constitutional amendment. This is a case called Marbury versus Madison. We'll talk more about that in a second. You can see that it was decided in 1803, so it was actually a decision very, very early in our nation's history. But this notion of a judicial review for constitutionality purposes is not explicitly stated in the Constitution. Despite that fact, it is now very widely perceived as a very important part of the power of the judiciary. But the second one is a part of a long-standing tradition. This has to do with the common law. And this is actually, this idea, the second one, is the nugget that led the court to this larger decision, or this related decision, we could say. And this is the idea of judicial review. We've had judicial review forever, both in England and in probably any Commonwealth jurisdiction. And this is the idea that that there's going to be a review of the decisions that another branch of government has done to see what was meant, and potentially to determine if they're constitutional or not. Now, of course, the review can be simply to figure out what a particular statute, maybe there's a certain level of ambiguity in it or something along those lines. So the idea that the judicial branch can review statutes and things like that is a longstanding part of our law. The part about the constitutionality is the part that was initially somewhat controversial. So here are the members of the U.S. Supreme Court currently. Unfortunately, Mr. Scalia recently passed away, so I'm going to just put a D over him. This is the gentleman who is no longer alive, and he was replaced by Neil Gorsuch. So imagine Mr. Gorsuch seated here, and you can see the members of the judiciary. For this class, you're expected to know 3 justices. This is John Roberts. He's our Chief Justice. This is Clarence Thomas, currently our only African-American justice. And we have Neil Gorsuch, our most recent appointment to the U.S. Supreme Court. He was appointed by President Trump. I encourage you to get to know all the justices, but those are the only 3 that I'm going to expect for you to know in this particular class. Okay, so this is that Madison versus Marbury opinion. Here are a few excerpts, but the gist of it is that the important idea behind this is that the U.S. Supreme Court has the power to find laws passed by Congress to be unconstitutional, and the idea that the basis of that opinion was that the U.S. Supreme Court said, look, if we didn't have this authority, if the only person who was able to decide whether a law was constitutional or not was Congress, the same entity that was making the laws, then really they could say that the Constitution said whatever they wanted it to say. There'd be no check on their power. And so the Constitution would really be a very empty document. So that was the argument, and it won the day. Okay, now let's talk about the check the judiciary has on the executive branch. And just like it can find laws of the legislative branch unconstitutional, it can find executive and branch actions unconstitutional. And we've seen that recently with President Trump's changes to visas and the restrictions that he wanted to apply. Many courts have found those to be unconstitutional. So that's an example of a check that the judicial branch can have on the executive branch. So those are the checks and balances. Just a little reminder, federalism does not equal checks and balances. Checks and balances do not equal federalism. Checks and balances have to do with the balance between the executive, legislative, and judicial branches. Now we're going to discuss a few provisions in the U.S. Constitution. It's important that you know the names of these provisions. It's not important that you know their location within the Constitution. Okay, so let's get started on the Commerce Clause. The Commerce Clause is hugely important to business, probably the most important clause of the Constitution with respect to business. It is how the federal government has the ability to regulate business. Most of what the Congress does, it has to do with the economy, it does because of the Commerce Clause. Let's pause for a moment and just do a little bit of a reminder about how the Constitution works. The Constitution gives specific powers to the Congress. It doesn't give them a blank check. It doesn't say, well, do whatever you want. You know, it says, no, you have these specific, and it's usually called enumerated powers. So whenever Congress acts, it has to point to some provision in the Constitution that says, yeah, we get to do this because of that sentence in the Constitution, or we get to do it because of this sentence in the Constitution. It has to have some authority. It can't just say, we want to do it, so we're going to do it. And so very commonly, the Congress points to the Commerce Clause for this authority when it wants to regulate business. So when you deal with business regulations, you may think they're great things, you may think they're awful things, but whatever you think about it, almost certainly the Commerce Clause is the authority that the Congress would claim. Now, when the state government regulates business, and the state government does have the ability to regulate business, obviously they're not pointing to something in the federal Constitution, they would need to point to something in the state Constitution. For the most part, the federal Constitution does not regulate states, although we'll see a few examples where it does. But for the most part, it's focused on the federal government. Keep in mind again that our founding fathers were very concerned about the federal government. They were used to dealing with their particular states, or obviously colonies back in the day. They had a lot more, trust in that system. And they also knew that they were going to establish checks and balances within each one of those states, independently of this federal Constitution. And so their focus in the Constitution was limiting the power of the federal government, not really focusing very much upon state government. So what does the Commerce Clause say? And this is the complete language from it. To regulate commerce with foreign nations and among the several states and with the Indian tribes. So the term is regulate commerce, and usually these are the keywords, among the several states. So this is interstate commerce. You can see that's not a lot of words to analyze. And so when the Supreme Court has to decide, well, does the Commerce Clause give the Congress the authority to do X? It has to, the U.S. Supreme Court has to decide, what does it mean to regulate commerce? And actually, the Commerce Clause has almost been like an accordion over the years. If we were to go back, say, to, we'll say 1917, we would find that this clause in the Constitution had a relatively narrow meaning. The U.S. Constitution would not have interpreted this to be a very broad level of authority for the federal government to have. But during the New Deal, when President Roosevelt was president during the Great Depression in the 1930s, he wanted to have a lot more ability to transform the economy in ways that he thought was going to help us get out of the Great Depression. And so he advocated for the U.S. Supreme Court to have a much more expansive understanding of the Commerce Clause. And he was somewhat successful, and he started a trend that continued. We'll discuss in another chapter a very important case from the 1965 that talked about expanding the power of the Commerce Clause. In recent years, the Commerce Clause has contracted a little bit from the most broad interpretation that we saw in the 60s, 70s, and 80s, but it hasn't significantly contracted. And so it's an interesting evolution that we're seeing. This is a big case with respect to the Commerce Clause. This is one of these decisions that came down when President Roosevelt was president during the Great Depression. And in this particular decision, NLRB, that stands for National Labor Relations Board, versus the steel company. And again, this has to do with unionization. The steel company did not want its workers to be unionized. The workers apparently did want to be unionized. The National Labor Relations Board wanted to support the workers' ability to unionize. And the statute that was relevant to this was the National Labor Relations Act. Well, the steel company is saying this law is unconstitutional. The Congress doesn't have the legal authority to regulate or to create a system so that workers can unionize if the employer does not want the workers to unionize. Well, the federal government says, well, yes, we do have this authority under the Commerce Clause. We have the authority to regulate commerce. One of the aspects of commerce is how workers are organized, and so we think that that is covered by the Commerce Clause. And the U.S. Supreme Court disagreed with the NLRB and said when we say we here, we're talking about the U.S. Supreme Court, we think it clear that the National Labor Relations Act may be construed so as to operate within the sphere of constitutional authority. But I'll tell you, they say it's clear, but if this decision had come down in 1927 or 1917, it probably would have gone the other way. So what's clear and what's not clear isn't always clear, so to speak. Let's look at the next aspect, and that is the state police power and the Dormant Commerce Clause. Let's first of all talk about the Dormant Commerce Clause, because this kind of connects with what we were talking about when we were talking about the Commerce Clause over here. Dormant is not a word we use every day in English. If you speak French or know some French, you probably are familiar with the word dormir, which means to sleep. And so dormant in this context means sleeping or hidden or implied in this context. And the Dormant Commerce Clause is a theoretical restriction that one can read into the Constitution, and it basically limits the authority of states to legislate in areas that the Congress can legislate. If the Congress has the power under the Commerce Clause to regulate interstate commerce, then the assumption is that states can't pass legislation that improperly burdens interstate commerce. So that's kind of the flip side of the Commerce Clause, this Dormant Commerce Clause, and its limitations upon the state's authority. Let's also consider the police power. When I hear the word police, I think about sirens and people pulling you over for, driving too fast or something along those lines. And certainly that is part of the police power, but that's not really the major focus of the police power. The police power has to do with the health and safety and welfare of citizens. And this is something that states primarily are responsible for. Each state is going to pass laws and have agencies that support this. So we're going to have things like building codes so that buildings are safe for people to live in and function. There'll be rules such as buildings need to have sprinkler systems, buildings need to have fire escapes and smoke alarms and things along those lines. We'll also see that another part of the police power would be criminal laws. Zoning rules. You don't want to have a liquor store next to an elementary school, for example. You want to have restaurants that make sure that there aren't roaches and rodents in the premises, and that workers, keep their sanitation levels very, very high. And so that's another part of that police power. A regulation of doctors and nurses would fall into that category. So you can see it's much more broad than just police officers, although certainly would be included in that. And for the most part, this police power we're going to think of as residing with the state government. That's one of the areas of responsibility under federalism that falls primarily to the state. Although, of course, some of these things do have some applicability on the federal level. We'll continue on in another lecture. Thank you for your attention, and we'll continue on to our next slide in the next lecture. Have a good day.